Welcome to Chapter 4, Common Law, Statutory Law, and Administrative Law. The law is complex, there's no doubt about that, but it can become less baffling if we understand the different types of law and how each type is made. Progress everywhere today does seem to come so very heavily disguised as chaos. Common law is simply judge-made law. 200 years ago, almost all law was common law. Most new law today is statutory. Common law predominates in tort, contract, and agency law, and it's important in property and employment law as well. It's based on stare decisis, meaning let the decision stand. It incorporates predictability as well as flexibility. Historically, the common law has required no action at all from those who witness a person in distress. The bystander has been free to walk away, laughing if he wished. Over time, changes in society's norms have an effect on long-standing common law. An example of this is a law that applies to bystanders in emergencies. Under common law, bystanders have no obligation to assist a victim in an emergency. Over time, courts have created exceptions, making employers obliged to help an employee who is suddenly stricken with an emergency situation when the employer is present. Some courts now hold that anyone witnessing an extreme situation, or if there is a special relationship, such as patient-therapist, should be required to help, though this is not universal. Is the bystander rule immoral? What are the differences between law and morality? Law clearly differs from morality. Anytime the two strongly diverge, it's worth close scrutiny. What about Good Samaritan laws? Many people misunderstand the effect of Good Samaritan laws, believing them to obligate bystanders to render assistance to someone in need. But this isn't the case. It merely protects people who decide to help someone from getting sued if they do more harm than good. If you've received certifications for completing Red Cross First Aid, Junior Life Saving, or CPR courses, you may have actually been told that such certification imposes a duty on you to provide assistance to bystanders when legally you aren't obligated to do so. You may recall from years ago the final episode of Seinfeld in which Jerry, Elaine, Kramer, and George laughingly watch someone being mugged and robbed while they do nothing to help the victim. They're arrested and charged with violating a fictional Massachusetts town Good Samaritan law for the failure to come to the victim's assistance. The show ends with the four characters sitting in jail. Though Massachusetts doesn't have a Good Samaritan law like it was depicted in the show, it nonetheless created a good topic for conversation. Most new law is statutory and passed by either a state legislature or the Congress of the United States. People who vote have some control over statutory law. We elect the state congressional representatives and the United States senators and representatives. Suppose you were on a state Supreme Court and faced with a restaurant choking case. Should you require restaurant employees to know and employ the Heimlich maneuver to assist the choking victim? If they do a bad job, they could cause additional injury. Should you permit them to do nothing at all? Is there a compromise? What social policies are most important? It appears that no state requires restaurant employees to give first aid to choking victims because of the possibility that they could do more harm than good. But some states do require the restaurant to respond. The Wyoming court has ruled that a restaurant has a legal duty to summon aid for a choking victim, but no duty to provide the aid itself or train the staff to do so. Any member of Congress can initiate a bill. It's then debated in a committee in the House where it's introduced. From the committee, it goes to the full House for a vote. If it passes both houses this way, it goes to the President for his signature. If the President signs it, the bill turns into a law. New bills are proposed all the time because new issues or concerns develop all the time. When people find a judicial ruling unfair or no longer effective, then Congress may try to pass a new statute to undo the decision of the court, unless, of course, the decision is based on the U.S. Constitution. It's also incredibly important for criminal law to be very clear so that it's not left up to judicial interpretation whenever someone's on trial. Let's say that you just signed a 2-year lease with a landlord for an apartment. The rent will be $1,000 a month. A clause in the lease requires payment on the first day of every month. The clause states that the landlord has the right to evict you if you are 1 day late with the payment. You forget to pay on time and deliver the check to your landlord on the 3rd day of the month. He starts an eviction case against you. Who should win? If we enforce the contract, what social result does that have? If we ignore the clause, what effect does that have on contract law? Virtually every state would refuse to enforce the clause, finding it unconscionable. An unconscionable clause is one that grossly and unfairly favors the party with more power. The example I just gave is such a clause. But the problem with permitting this flexibility to enter into the contract law is that we now are less certain of being able to enforce contracts generally. A party who wishes to get out of a contract may attempt a claim of unconscionability. Sometimes wording is ambiguous, which leads to statutory interpretation. New laws must be interpreted by the courts. Plain rule meaning means that the courts must use the common sense definition of words. Legislative history and intent means that sometimes the court can look to the reasons behind the law to determine the legislature's intent. Public policy means that the courts will use accepted social policies such as reducing crime or providing education to interpret a law. Once a statute has been applied by the courts, its interpretation becomes a precedent to be used in future court cases.